Welcome everyone. Rilus Dana here. I'm live right now. All the places for me, that is. So I'm on Maat Legal, where I have a lot of real estate investors that are tuning in there. I'm also on my Dana and Associates pages. So Dana and Associates is my law firm where I practice law in Arizona and California. I practice estate planning and probate. So this video, I wanted it in all the places. This is a question that I get from a lot of my law firm clients. So I want to make sure I have a good answer on the YouTube and Facebooks if they go to look for it there. But we're going to talk about what to do after the loss of a loved one. So this is going to be really helpful if you're named as the successor trustee in the trust, or if you're named as a personal representative in the will, or even if there's none of those things. If someone passed away, this is going to be helpful. So these are the steps that I go through when I'm looking at an estate. Let me share my screen here. Okay, so this is where I practice law, Arizona, California. What to do after the loss of a loved one. So the first thing that I look at is what are the assets? So I think that's a logical place to start. First, you look at, what is out there. So in this case, there might be an IRA or retirement accounts. Maybe there's life insurance, bank accounts, some real estate, but get an idea of what the assets are. Let's talk about some terms. So we want to define the players. So decedent is the dead person, the person that passed away. Fiduciary is who's in charge. Beneficiaries, who gets the stuff, who are things going to, who's entitled to receive. All right, and third, you want to get an idea of what controls the assets. So things like IRAs and life insurance, they commonly have beneficiaries listed. So if there's a beneficiary designation on those contracts, that's going to be controlling. So look individually at the assets, see if there's a beneficiary listed. And then you want to see how things are titled. So the house, in this case, is titled in the name of the deceased. It could be titled in the name of a trust. Bank accounts, they may have a beneficiary listed, or they could be owned by a trust. So when you look at the assets, you want to learn how they're titled. It's really important to know if it's titled in the name of the deceased, is it titled in the name of a trust, and are there any beneficiary designations? So what controls the assets? So for assets in the name of the deceased, they'll be controlled by their last will and testament. That is, if they have one. The last will and testament is a document that names the beneficiaries and who's in charge, the personal representative. If there's no will, then you look at the laws of intestacy. Uncle Sam's got a plan for you. So if there's no will, you look at the default rules to see who the estate is going to go to. If it's in a trust, then you take a look at the trust to see who's listed as the successor trustee and who the beneficiaries are. Now, if you are the fiduciary, you're going to have to pay extra close attention. So if it names you as the one that's in charge, here's some of the things that you need to be doing. So you need to safeguard the assets and start an accounting. So as you're getting an idea of what the assets are, start keeping track of that information. You need to formally get appointed. So if you need to do a probate, you're going to have to file with the probate court to get appointed. If you're listed in a trust as a successor trustee, you still need to get appointed. You need to accept that position, and you need to prove to the banks and the institutions that you are the trustee. You also need to report to the federal and state governments. You'll probably need to get a tax ID number for these things. They may have been acquired beforehand, depending on the type of trust. But with the regular revocable trust, it does not get a tax ID while it's being managed by the trust creator. So after the trust creator or creators, if it's a married couple, after they both pass away, then a tax ID number will need to be created. All right, so once you get appointed, then you follow the instructions. You follow what the trust or will says or the laws of intestacy. Now, this I use this green hat as a symbol for the fiduciary. Whenever you're wearing this hat, you have what's called a fiduciary duty. We're going to get into that more in a second, what that is. I'm biased as an attorney, but I always recommend that you get an attorney. I think it's a good idea to get representation so you don't get sued by your siblings or sued by the beneficiaries of a trust. When people hire me to represent them as trustee, that's ultimately what they're hiring me for, to help them follow the rules. And sometimes there's bad trust or crappy documents. Hopefully, I didn't prepare them, but I've administered a lot of trusts that were not great. So that's when it gets difficult, or I say that's when it gets fun, when you got to practice law, when it's not so clear what needs to be done. Now, depending on the terms of the trust, it might require you to create additional trust. If beneficiaries are underage, or if they're special needs beneficiaries, or if it's what we call a dynasty trust, those extra trusts are going to need to be created, which means getting a tax ID number, again, reporting to the federal and state governments. And then after you get the subtrust created, if any, then you got to collect all the assets and then determine if there's any valid creditors of the estate, and then negotiate with those creditors. Again, that's a big role of the fiduciary, I believe, is to negotiate with creditors. I see a lot of attorneys that just pay everything in full. With a lot of things, it's really easy to get them to reduce it by 50%, sometimes even 70, 80%. So that's something that we do for our clients, is we'll negotiate those debts for them, try to get them reduced and get as much possible for the family. And then after that, after everything has been settled, all valid debts have been paid, then it's time to divide the assets. So if you're a beneficiary, what you should be doing is you should be in the know of what's going on. So ask for a copy of the legal documents, ask for an accounting, and be patient. So what I tell people is if they got a copy of the legal documents and they're showing them what the assets are in the trust and the estate, give them time. It often takes a while to, sometimes they have to sell houses or whatever it may be. It can take a little bit to settle an estate. Now, if you feel like you've been patient for too long, and months and months, maybe close to a year, I would say, is when if nothing's happening outside of if you've already received copies of the legal documents and an accounting, but it's not moving, then you might want to see an attorney to advise you of your rights. All right, so that's it for this video. Hope you found that helpful. I have another resource I want to show you. So you can go to the Maat Legal Academy here, and I've recorded a course here that goes a little bit further for the successor trustee, what they need to do. If you're a recent client of my law firm, you've received the code to this in your binder. So this is now included as part of all of our estate planning packages. We have this extra guide for the successor trustee, which explains what they need to do. If you're not one of my clients and you want to see this, then you can leave a comment in this with your email, and I'll email you that coupon code so you can check this out and get some help if you're the trustee of a trust. Hope you found this helpful. Let me know what other videos you'd like to see in the future. Thanks.